Pleasure to see everybody out here tonight. Tonight's program was actually inspired by another program that I've been doing for SCORE for many years. For many years, I've been doing a program for SCORE on copyright law basics for artists, photographers, authors, and other creative types. Those of you watching the video, you can actually see this on my YouTube channel. If you go to youtube.com and search either for Cliff Enico or Cliff Enico channel, you'll see all the videos I have up there, and the Copyright Law Basics program is one of the ones on the YouTube channel. But something we discovered recently is that when I do the copyright law program, all the questions that I get at the end of the program have to do with trademark law. So SCORE asked me, could I please do a companion program on trademark law basics? I said yes, and that is what you're going to be hearing for the next 45 minutes or so. So I call it, What's in a Name? If I had to pick the 5 most common questions that I get in my law practice, you know, how do I keep from getting sued? I got a letter from the IRS, what do I do with it? One of the top 5 questions, though, that I get all the time is, Cliff, I'm launching a consumer brand. I want to trademark my name. How do I go about doing that? That is one of the top 5. There's a lot of misunderstanding about trademark law, and we're going to try to clear up some of that confusion tonight. It's a pretty complicated topic, but I'm going to try to make it simple. First of all, now, if you ever doubted that I was a lawyer, you now know it now. Lawyers always tell you what they're not going to do before they tell you what they're going to do. A couple of disclaimers. Obviously, I am not a SCORE employee or counselor. You know, so if anything I say here sounds like good advice and you follow it and it totally does not work, and you end up losing your house and your business and your family and your dog and end up living in a diaper box under the Brooklyn Bridge, you cannot sue SCORE. You also cannot sue me. Well, I'm a lawyer. Go ahead. Knock yourself out. But the second disclaimer is more important. Well, I certainly am going to be giving out a lot of legal and tax information tonight, and I'm going to try to answer your questions as best I can. I don't really know any one of you well enough to be able to give you one-on-one advice. You know, I can certainly say, you know, this is how trademark law works, but what I can't say is you should do this and you should do that. For that, I would have to know you a lot better than I do. Quite frankly, I'd like a little money for that too. But more importantly, I'd have to know your situation a lot more in depth than we're going to be able to do in a 45-minute program. So just keep in mind that, you know, this is no substitute for advice. Like all my programs, this is no substitute for an advice that you would get from a lawyer who's licensed to practice in your state and specializes in this area. So, naming your business. This is by far and away the hardest part of any startup, is finding a bloody name for the thing. It used to be very easy. You know, back when I was a kid growing up, you know, if you wanted to name a business, let's say you wanted to start an antique store, it was easy. You know, what you did was you took a vacation. You went to some other part of the country where there was lots of antique stores, and you go around, you'd find a name that you like, and you basically stole it. And nobody cared about that. You know, they're in Pennsylvania, you're in Connecticut, you weren't stealing any business from them, they weren't stealing any business from you. You know, if it was a cute name, you know, why not? You can have different businesses with the same name in different states, and nobody cared. But today, we have this wonderful thing called the internet. You know, that antique store in Pennsylvania with a cute name isn't just a cute little antique store in Pennsylvania. They have a website. They're selling on eBay and Amazon to 50 countries around the world. They are building a national, if not an international brand around that name. And if they see you using the same name for a similar business, the baseball bats will come out and life will become very unpleasant. So the internet has complicated this world in a very big way. It's a lot harder to name a business than it was when I was a kid. When you're looking to name a business, it's a 5-step process. And the most important really isn't a legal thing at all. Is it memorable? Can people remember this name? That's important. You know, my name is sometimes a little bit difficult to remember, my last name, because of the 2 N's and stuff, and people do all kinds of crazy misspellings with it. You want to have a name that the minute people see it, it will stick in their head for at least 24 hours or so, at least until they can get to a computer and look you up, or a smartphone and look you up. Is it memorable? Is it easy to memorize? The second question, can you get a registered trademark? This is what we're going to be spending most of our time talking about tonight. Can you get the website URL, preferably the .com? People expect you, if you have a small business these days, people expect you to have a website of your own. If you're Susie's Fantasies, like a gift shop or something, I expect you to be susiesfantasies.com. And if I don't see you there, that's a real buzzkill for me. That's a real ding to your credibility. I want to see that you have it. And it's not as easy as it used to be. It used to be that you could be cliffedico.com. Now you have to be Cliff Enico, world's greatest small business lawyer, who, yes, does look a little bit like Richard Nixon when you look at him closely, but he's really a great guy once you get to know him, .com. That's what you have to be now. It's getting to be more longer, more involved, and it's harder to get good names. Is the company name available in your state? We're giving this program in Connecticut, but you should check your Secretary of State's office. That's the place where you register corporations and LLCs. Make sure that somebody else does not have that name. In my experience, any name involving initials is probably going to be problematic in most states. J&L Enterprises, A&B Associates. There's probably some gas station in some remote part of your state that has that exact name. So check your Secretary of State's records. And then last but not least, just do a quick internet search and see if there's anybody out there using that same name. Just type the name into Google or another search engine and just see if there's anybody else out there. And if there is somebody else out there, is it a small mom and pop in a remote part of the country, or is the trademark owned by Microsoft? If your name is owned by a big company or someone bigger than you, find another name. You don't want to launch a lawsuit against a big company. It's a no-win proposition. Okay, so now let's talk about trademarks, okay? A lot of confusion here. A trademark has nothing to do with ownership. I hear people say all the time, well, if I have a trademark, that means I own the name. I own it. The answer is you really don't. You really don't. I mean, it is intellectual property. You do have the certain rights to use that name, but it has nothing to do with ownership. You cannot own words in the English language or graphics or logos. It's a much different concept. What a trademark is a legal monopoly. Now, if you know anything at all about our legal system, we don't like monopolies. You know, monopolies are bad. They have too much power. They increase purchase prices. You know, it makes it hard for consumers to afford basic things if we have too many monopolies. We like free competition in this country. But a trademark is a legal monopoly. It's a monopoly that is sanctioned by law. If you have a registered trademark, what it means is that for a certain period of time, and we'll talk about how long in a little bit, you have the exclusive right to use that name in commerce on your goods or services, whatever it is, for a certain period of time. No one else can use it. If someone else is using that name, you can sue them for infringement and shut them down. It's a very powerful weapon. And copyrights and patents, of course, are other types of legal monopolies. But here's where the biggest confusion is. You don't trademark a name. What you trademark is a mark. Now, a mark can be a name. It can be a collection of words in the English language, you know, like monster, you know, for lookingforjobs.com or for looking for jobs online. It can be a word, but it's not just a word, it's a mark. It is a trademark is something that you put on your products and services that identify them in the stream of commerce. There's a lot of history here. Once upon a time, most people were illiterate. They didn't know how to read or write. So when they went to the local grocery store, they couldn't read the labels on packages. What they identified was the color of the box. Some of you may remember pasta companies like Ronzoni years and years ago. They always had numbers on the boxes. You know, Ronzoni Orecchiette number 67. You remember that? They don't do this anymore, but some people, you baby boomers in the audience might remember when we were kids, they did that. That's because a lot of Italian and other immigrants to this country did not speak English. They didn't know whether it was orecchiette or some other kind of pasta. They went by the number. They would tell their kid, hey, go to the store, get number 67. That's how they did things back then. So this is where trademark law comes from. It comes from the marks that you put on your products and services. And it doesn't have to be a word. It can be a logo, a design. So it could be a character. So for example, the Pillsbury Doughboy is a registered trademark of Pillsbury, the bakery company. The McDonald's Golden Arches are a world famous trademark, of course. But it can be a name, it can be a word. But the important thing is it's a mark. It identifies your products and services so that when people walk down the grocery aisle or wherever your products and services are sold, they know that this is you. This is your stuff, and that's the genuine article, okay? If you are planning on branding your business, and I'm dealing with a lot of people these days that are looking to brand things, you need a registered trademark. End of story, world without end, amen. It is that simple. If you are trying to establish a brand identity for what you do, you need a registered trademark. Trying to build a brand without a registered trademark is a fool's errand. And I hope you don't mind that I'm being a little abrupt with that. You know, sooner or later, I see a lot of people starting businesses and they're saying, well, we might use this one mark, we might use another one, we're just going to wait and see how the market develops. No, bad idea. You know, that trademark comes first. Before you even spend money on a lawyer like me to put together your LLC or deal with your contracts or anything like that, you need to have that registered trademark nailed down. That's where your money needs to be spent. You got to get that right, because that is what the whole brand is going to be built around. And it's very, very important. Last but not least, if you're doing a service business, technically we don't call them trademarks, we call them service marks. I'm going to refer to trademarks throughout this program, but obviously if you're doing a service, it's technically called a service mark, not a trademark. But you go through the same process, you register in the same place. Okay, trademarks versus copyrights. Okay, a lot of people get confused by this. Both are forms of intellectual property. Both give you a legal monopoly over certain things. You trademark marks used to identify goods and services in commerce, brand names and logos. You copyright slogans, although that's not 100% accurate. If you have a slogan that you are using on your packaging as part of your identifying mark, you can trademark that. So for example, Maxwell House Coffee, good to the last drop. If you look at the can of coffee, there's an R in a circle after both Maxwell House and the good to the last drop. They've trademarked both of those. A slogan can go either way, but for a slogan to be trademarked, it has to be used on your packaging or the materials that you use when you sell your products and services. If you're not using the slogan on your packaging, you're in the copyright world, you're not in the trademark world. And then marketing copy and graphics other than logos. So websites, for example, always have the copyright symbol at the bottom. You can't trademark a web page or a website. Okay, now, common law trademarks. Believe it or not, you are not required to register a trademark with the Federal Trademark Office, although it's a darn good idea. And if you're thinking about building a national or interstate brand, you have to do it. We'll talk about that a little bit more later on. But there is something out there called a common law trademark. Have you ever seen a package where there's a name and a little letter TM or SM following it, and usually in the upper right-hand corner there? That's a common law trademark. A common law trademark basically says, I may be able to register with the Federal Trademark Office, but I'm not sure, and until I'm sure and until I'm willing to spend the money, I'm claiming it as a trademark. So if anybody out there is thinking of using the same name for a similar product or service, I'm going to grab my lawyers and come after you with baseball bats. That's basically what the little letter TM, this is a package, a lot of language in that little language, but that's what you're doing. And it's perfectly legal. You do not have to register it with anywhere. You can put this on anything you want. So Cliff's Antiques, well, I probably will not be able to trademark that with the Trademark Office, and I'll tell you why a little bit later. I could always put a little TM or an SM on that and say, I am claiming this, you know, as a trademark. So if anybody else wants to be Cliff's Antiques in Connecticut, you got to go through me. They do not need to be registered with the Trademark Office. And you can sue for infringement with only a common law trademark, but it's a very weak claim. There are much stronger defenses to a common law trademark than there are to a registered trademark. Much easier for the other person to win. So you can sue for infringement, but if all you have is a TM, it's a much more difficult fight. The biggest defense that they're going to have, which we'll see in a minute, is, well, wait a minute, you can't really trademark that. Nobody can trademark that. You're right, I can't trademark it either, but neither of us can. You really cannot claim Cliff's Antiques or Joe's Garage as a trademark, and they probably would have a pretty good claim there. Okay, so now let's talk about registered trademark. These are identified by the letter R in a circle. For those of you who use Microsoft Word as your word processing program, you go insert symbol, and it's in there. You can stick it into the text of whatever it is you're doing, your PowerPoint, your website, whatever it is. This must be registered with the U.S. Trademark Office, which is uspto.gov. Be very careful, it's not uspto.com. That is, I think, a porn site or something like that. No, seriously, a lot of quasi-legal websites take the government's name and they put a .com or a .net after. It's .gov. If it's a government agency, it's almost always a .gov, so be careful. It is a federal crime to use the R in a circle if you have not registered with the federal government. I will repeat this. It is a federal crime to use the R in a circle if you have not registered your trademark with the federal government. You can do the common law trademark, the little TM or the little SM, that's okay. But if you're using the R with a circle, that has to be registered with the government. If I see you using the R in a circle and I cannot find you on the trademark register, I'm going to have a problem with that, and your attorney's going to have a problem with that. I mean, I don't know what the fine is. It's not imprisonment. I think it's a fine of like $5,000 or something like that for each use. You don't want to go there. You can sue infringement, and the registered, and this is the thing, you still are not 100% in the clear. If I had to pick the biggest myth about trademarks, it's this. Everybody thinks, oh, I get a registered trademark and that's it. I am absolutely the owner of this name and I can shut down anybody else who uses it. But that's not 100% true. That's not 100% true. If someone can prove that they were using that mark in commerce before you, then they will still have the right. You don't lose your registered trademark, but they have to have the right to use it in the area in which they've been historically operating. And there's a famous case regarding that, one involving McDonald's, the hamburger chain. Quite a number of years ago, they sued a small mom and pop restaurant, I think it was in Illinois, somewhere in the Midwest, called McDonald's Family Hamburg Restaurant. Now, right off the bat, you hear the name Hamburg rather than hamburger. This is an old restaurant. They had been operating in that area since World War I. And of course, McDonald's was only founded sometime in, I think, in the 1950s. So McDonald's tried to shut them down for trademark infringement. It went all the way to the Federal Appeals Court in Chicago. And they said, no, this restaurant had the ability to continue using that name within their sphere of influence. As long as they don't use any of McDonald's, they don't use the Golden Arches or any of McDonald's other trademarks, because the name McDonald's itself was not trademarkable. Very interesting case that came out of that. The little guys won for a change. I'm surprised they didn't make a movie out of it, quite frankly, because Hollywood loves those kind of shaggy dog, David and Goliath stories. I'm surprised they never did a Hollywood movie out of that. So you may have to live with some other people, even with a registered trademark, you may have to live with some people using that other name. But if they started the company and started using the mark after your date of registration, you can absolutely shut them down. That's what having a registered trademark does for you. And no one else can use www.yourregisteredtrademark.com. Even that company that's been around since the World War I will not be able to grab the website URL for that. That is one of the benefits of a registered trademark, is that .com is always going to be yours. You will win that fight virtually every time. Okay? There are state law trademarks in most states. Connecticut definitely has a state law trademark. The federal trademark obviously covers the entire United States, territories, and possessions. The state trademark only covers your state, okay? State trademarks, I think, are basically useless unless your business is an extremely local one. If you have a local restaurant, let's say, that draws 90% of its customers from within a 10-mile radius of where you are, maybe a federal trademark is a little bit overkill. Maybe a state law trademark is okay, but I got to tell you, it's just as costly to get a state law trademark as a federal trademark. So why not, spend the extra $10 and get a federal trademark, which will protect you. Maybe you want to franchise your business at some point. The federal trademark will protect you throughout the entire country. But also too, the state law trademark is. But the one thing good I can say about a state law trademark is it's a lot easier to get. The examination process is a lot less rigorous than it is at the federal level. So for example, if you have a name that you're not really so sure is trademarkable, you might be able to get a state law trademark where you wouldn't be able to get a federal law trademark. If your trademark lawyer says this is kind of an iffy name, and especially if you have a local business, you're not selling across state lines, it might make sense to get a state law trademark in that very narrow situation, but otherwise they're worthless. I hate to say it. Also, too, I would love to be a trademark examiner in the state of Connecticut. I think they only get like a few applications a year or something. It's got to be one of the cushiest jobs in all of government. I have to believe that. I don't think these people are sitting there waiting for applications to come in. And keep in mind, even a federal trademark does not protect you when you are doing business overseas. It only applies within the national boundaries of the U.S., Puerto Rico, Guam, and the Virgin Islands, and other territories and possessions. Okay, so what about overseas? Okay, In the copyright world, this is easy. There are a couple of treaties. There's one called the Berne Convention, for example, which just about every major country in the world has signed, that says that if you copyright a work in a member country that has signed that treaty, you're automatically considered to be copyrighted in all the other countries. What a great idea. There is no similar idea for trademarks. The treaties for trademarks are all over the place. I've given you the website here. This is a summary. It's a nice web page I found that summarizes all the international treaties. If you might want to take a picture of this slide, just because that's a very long URL, and I apologize for that. But it describes all the various treaties: the Madrid Protocol, the Madrid Agreement, which is different than the Madrid Protocol, the Paris Convention. There's about a dozen different treaties, and different countries have signed on to different ones. But the thing is, it's not automatic. You still have to register and identify the participating countries where registration is desired. So, for example, the European Union, the EEU, does have a trademark treaty now that says that you can register. By registering with the EEU in Brussels, you're automatically considered registered in other member countries, but you have to select the member countries that you want. It's not automatic. The form has a checkbox, and you basically check the countries where you want to have trademark protection, and and the fee depends on how many countries you sign up for. It's not automatic, where if you just fill out the form, you're registered everywhere within the EU. You get to pick the countries that you want to register in, and not every country has signed a treaty. China, for example, has not signed any of these trademark treaties that I'm aware of. North Korea, of course. Of course, if you're selling goods to North Korea, you probably have bigger legal problems than trademark. I think there are other agencies of the government that are going to want to speak to you at some point if Kim Jong-il is using your stuff, or whatever his name is. Kim Jong-un, I'm sorry, I got it wrong. That was his father. Okay, how long does a trademark last? Okay, once you get it, it's 10 years after registration, and you must renew it. This is unlike a copyright. Once you get a registered copyright with the Library of Congress, it lasts for the life of the author plus, I think it's 75 years. Here, you must renew it or you lose it. Every 10 years. You do not have to, and every time you renew, you have to prove that you're using it in commerce every time. The Trademark Office does not assume that. You have to send copies of your packaging. You have to show them that you're using it in commerce. You can renew indefinitely. There's no time limit or anything like that, but you lose it if you stop using it in commerce. If you stop using the mark, even though you file the renewal, you have lost the trademark at that point. So for example, and this is something I learned the hard way. Back in the 90s, I ran a desktop publishing company. It was called Bienix Press, Bienix Corporation. And I wanted to trademark the name Bienix, which I felt I could do. It's a made-up word. It's a corruption of two Enicos. Bienix, that was what it meant. It wasn't a word in the English language or anything like that. I thought I would sail through. And so I did it myself. I filed the trademark application, and I got bounced, not because the application was bad, but because I sent them copies of some of my book covers and stuff, and I wasn't using the name Bienix on my book covers. And that's where they nailed me. I was using the letter B, like a lowercase letter B, on my spine of my books and stuff like that. I wasn't using the word Bienix. The examiner came back to me and said, send us this stuff back and make sure the word Bienix appears somewhere on the cover of the book, and then we'll register your trademark. And I did, and I did ultimately get the registered trademark for that. But that's a lesson I learned the hard way. You have to be using it in commerce. If you stop using it, then you automatically lose it at that point, which means that other people can now use that same mark for similar products or services. That's what it means. You still can use the mark. It just means that now you've lost your exclusivity. Other people can now use the mark as well as you. That's what happens. You must defend it against infringers. If you see other people using your mark for a similar service or product, you must have your lawyer send out the nasty cease and desist letter. You can't be nice here. The trademark laws require that you vigorously protect your trademark. So whether you like it or not, you are going to have to send nasty letters to people who are infringing your trademark if you find them. Because here's the big risk. Trademarks sometimes become generic. They become part of our language. And if they do, you lose the trademark. So for example, all the words escalator, aspirin, Kleenex, yo-yo, at one time, those were registered trademarks of various companies. But those companies lost the trademark because the name became part of our language. the name became generic for that type of product. And a lot of high-tech companies worry about this. When you search for something online, what do? You Google it, right? Even though you might not be using Google search engine. You might be using Yahoo or one of the other search engines that are out there, right? So Google got paranoid about this, and they actually brought in action. Somebody actually sued Google in Arizona, a guy named Elliott, and it went all the way, and it went up into the federal court, and the federal court said that no, Google did not lose the right to its trademark, even though it was becoming a verb. Now, that's a federal court in Arizona. I'm not so sure that I'm not aware of any higher court cases or Supreme Court cases. This is remaining open to challenge, and it's one of Google's big legal challenges right now, is the fact that people are using their name as, just a verb meaning to search online. Right? Those of you who use smartphone apps are coming up with other ways, too, to do things. This, the world of high tech, they agonize over this stuff. They do. They're desperately afraid of losing their trademarks. Okay, so now let's talk about choosing a trademark, okay? Not everything can be trademarked, okay? The Trademark Office has a lot of different exceptions, and it's a good idea to become familiar with those or hire an attorney who's familiar with these before you proceed. The name cannot be a generic term, so California Vineyards, for example, cannot be a registered trademark. If you have a vineyard in California, you can call yourself California Vineyard, is the idea. It cannot be, and this is the big one, merely descriptive of your product or service. So web graphics is not a trademarkable term. Anything that describes your products or services, what they do. Geographical, if the only thing distinctive about your name is the location, it cannot be trademarked. So Nantucket Nectars was not able to get a registered trademark for their juice products years ago, back in the 90s. It cannot be just a surname, Joe's Garage. Although interestingly enough, somebody actually has the trademark for Joe's Garage, believe it or not. The trick is, it's not for a garage. It's not for anything automotive or anything like that, because if it was, it would be knocked out as either descriptive or a surname. It's Frank Zappa. The estate of Frank Zappa, one of his albums from the 1970s was called Joe's Garage. And he was able to get a trademark for Joe's Garage for record albums and musical compositions, not for a garage that you would take your car to. So that's a cute example. We'll talk about this. Immoral or scandalous. One of my proudest possessions in my home, which I will share with you. And I know it's going to be worth money someday. I have a 6-pack of Bad Frog beer. Does anybody remember this? This was a major scandal back in the early 1990s. I was traveling around the country promoting my Money Hunt TV show back then, and there was a brewery in Michigan that came up with this beer. It wasn't really a local craft beer. It was more like a hopsier version of Budweiser. I tried one once. I didn't care for it that much. But the logo that they adopted, which was on all their labels, was a cartoon frog basically giving the world the finger. And that was the logo. I mean, look up, you can probably see, I'm sure there's a Wikipedia article or something online about Bad Frog beer. You can see what the logo looks like. But the Trademark Office kicked that out as being obscene or scandalous, and the beer company challenged it. It almost went to the Supreme Court, actually. It actually got up to the federal appeal court level, and the court threw the label out. They said that, no, this is no good. You can't do that. Kids, kids can see this label in the grocery store. Come on, this is, we don't want that. So if you ever get a Bad Frog beer, if you buy a bottle of Bad Frog beer or an empty one in an antique sale or something like that, keep it for posterity. I think it has serious collectible value. I think it does. Deceptive, a deceptive label, a label that implies a false connection to somebody else. So for example, if you develop a series of little rolls of toilet paper, like for people with RVs and yachts and stuff like that, and they're cute and they're very soft and they're tiny, and you decide to call them Microsoft toilet tissues, you're going to have a problem with the trademark office. I mean, you're not doing anything with computer software. He can't get you there, but I think he would say that this implies a false connection to his company or disparaging the product. I mean, who's your first customer going to be? Answer, Apple. They're going to put this in all their, all of Microsoft's competitors are going to put this in their men's and ladies' rooms in corporate headquarters. That's going to be your first customer if you're doing a product like that. Also, too, the likeness of a living person or a dead president, believe it or not. So if you're doing a Lincoln brand something and you want to use the picture of Honest Abe, believe it or not, you cannot do that. Not without the consent of whoever handles Lincoln's images, believe it or not, or his widow. Or the likeness of, so for example, if you want to put my likeness, if some of you guys are taking selfies of me right now, first of all, you have to find a label that's big enough to handle it, for which I give you the challenge of that here. I always tell my video people to always use a wide-angle lens, and that kind of stuff. But also, too, you got to get my consent. That's a violation of their right of publicity also in copyright law. For those of you who took my copyright program, using somebody's likeness without their permission, especially a celebrity, is going to get you into some very hot trouble, unless, of course, they agree, unless they go along with it. So, for example, when Paul Newman started Newman's Own, he certainly did allow the company to use his cartoon, his caricature on all the labels. You pick up a bottle of Newman's Own salad dressing, his caricature is right there. Okay, choosing a trademark. The big thing here, the name cannot be trademarked if it's confusingly similar to another registered trademark. When you file your trademark application, the thing that your examiner is going to be spending 90% of his or her time doing is looking into this. Is this name too close to another registered trademark? Are they confusingly similar? If I go into a store and I see these two labels, these two things, marks right next to each other, is there a chance I would pick up the wrong one? That's what they're looking at here. Confusingly similar is one of those terms you can't define. There are hundreds, if not thousands, of cases that deal with the question of whether two marks are confusingly similar. There are literally thousands of them, and this is what the examiners are focused on. If the examiner bounces you, 90% of the time is for one of two reasons. Either your name was descriptive and therefore couldn't be trademarked, or your mark was too close to somebody else's and the examiner was not comfortable. Okay? Bottom line is, do not do trademark searches yourself. Okay? In my copyright law presentation, I said that there's lots of stuff you can do in the copyright arena where you don't have to have a lawyer. This is not one of those worlds. Trademark is very different. Trademark searches are very difficult. The Trademark Office does have a search feature where you can search for trademarks online. So you can type in your name. It's called TESS, T-E-S-S. If you go to the homepage on uspto.gov, look for TESS, a search. You can do a check of your name. It's probably a good idea just to make sure that Microsoft doesn't have it. But if it doesn't find anything, that does not mean that somebody else does not have the registered trademark. All it means is somebody else does not have that exact thing that you typed in. So for example, one of the greatest things, so let's say for example you have a name that is not trademarkable. Your lawyer tells you absolutely no way is it trademarkable. One of the cute things you can do, we'll talk about this later, is you can have somebody design a logo that incorporates the name, the word that you want to use, and then trademark the logo. Sometimes that works. The name itself is not trademarkable, but the logo that includes the name, maybe in a funky graphic style or font or something like that, that might be trademarkable. If you do a test search for just the name, that logo, though, will not show up on the search. And so if you use the name in commerce, you're going to get a nasty cease and desist letter from whoever owns that logo. The test service is not perfect. It isn't. Lawyers know the intricacies of using it, but most people don't. Have an attorney do it. Spend a couple of $100 and have it done right. And be prepared for one of the strangest meetings of your life, because what you're going to do when the attorney has finished the search is they're going to sit you down with photos. You're going to feel like you're in a criminal investigation, like on CSI. They're going to show you all these photos saying, now look at these two. Do you think those two are too close? Now, how about this one? Look, now let's add this third one here. Is that third one closer to that one or to that one? Seriously, it's like you're looking at mugshots of murder victims or something like that. It's one of the strangest processes is going through a trademark search with an attorney. But this is why, because this is a very graphic world. McDonald's Golden Arches, I mean, let's say, the St. Louis Arch, those kind of look the same. An arch is an arch at a certain level. You know, how do you distinguish between those two? You know, this is what trademark lawyers, this is why a lot of trademark lawyers have engineering backgrounds as well as legal backgrounds. Because of that. I mean, remember those tests they used to give you in high school? You know, now take this picture here. Now, which of the 4 pictures is this thing turned 90 degrees to the left? Right? That's the kind of brain you need to have to be a trademark lawyer, to be able to look at 2 designs and say, nah, that one I'm not worried about. Those 2 aren't too close, but that one, yeah, put a little thing over there. Yeah, that's a little too close. That's the kind of brain you need to be a trademark lawyer, okay? Do not try to do this yourself. Seriously, get professional help, okay? Now, a name may be trademarkable if it is suggestive, not descriptive, but suggestive. So Mustang for a car, fast, fleet, you know, wild and free, right? That's what the word Mustang connotes. Copper tone, obviously, for the suntan lotion. Those are registered trademarks. They're not descriptive, they're suggestive. And the difference is really one of degree. If the name describes the attribute of the product itself, that's going to be a problem. But if it just describes something the product gives you, a benefit or a feature, it might be considered suggestive, as long as it doesn't describe the product itself. Yeah, I know. This is why trademark lawyers earn their money. Deciding between a suggestive and a descriptive name is very difficult. Arbitrary, by far and away the best trademarks. Names that have nothing to do with your product or service. Monster, Penguin for books, Camel for cigarettes. Fanciful or coin names, Exxon, eBay, my Bienix for my publishing company that I had back in the 90s. Those are the best trademarks. The best trademarks are names that have nothing to do with your product or service. They're the best trademarks at all. You know, Monster brand online search, Google brand online search. Say that phrase to yourself. Your trademark brand, and then the name of the product. You know, Google brand search, Ronzoni brand pasta, McDonald's brand hamburgers. Put your trademark that you want to use and the name of the product, plug it into that and see how it sounds. If it sounds good, you might have a good trademark there. You might have a trademark that'll work. Okay, now, so what happens if your name can't be trademarked? Okay, well, the good news here is if you can't get the R with a circle, chances are no one else will be able to do it either. The trademark rules are pretty specific, and it's highly unlikely that if someone applies for the same trademark 6 months from now, they're going to get it when you didn't. It's highly unlikely. They all follow the same rules, and they follow them pretty closely. So that tells you that maybe nobody can get this mark. You can then use a common law trademark. I also told you something, by the way, that's not on this slide. Maybe what you can do is have a graphic designer do a logo that incorporates the name that you can't trademark, and then go back and try to trademark the logo, the design. That's a common trick in trademark practice. You may not be able to trademark the word, but if you put it in the middle of a fancy artistic design that can be trademarked, the trademark office will allow that to go through. Do an online search to see if anybody else is using the same or a confusingly similar name, and develop what the trademark lawyers call acquired distinctiveness. Basically, what you got to do here is you got to market the hell out of your name and brand, and build it to the point where it's so ubiquitous and everybody knows it that if anybody else tries to rip it off, you'll have an easy trademark case against them, even though you're only using a common law trademark. What you got to do here is get big fast and get your name out into the marketplace so everybody knows that that brand belongs to you. That's the trick here. Acquired distinctiveness simply means that by virtue of your use of it, you kind of acquire enough of a distinction that the name is worthy of protection. You won't be able to trademark it, but you'll win the infringement suits when they happen. That's what that means. Or better yet, find a better name. Find a better name. I mean, sometimes you just gotta bite the bullet and come up with something better. Okay. Now let's go through the registration process. I am not going to go through this in a lot of detail because it's highly complicated. First of all, do the trademark search. No LegalZoom. Have a lawyer do this. LegalZoom, the last I looked, charges about $400 to do a trademark application, and they do a test search on the USPTO.gov, but they do not do the thorough logo and design search that a lawyer will do. So even though LegalZoom or some other company registers your trademark, there's a very good chance that you're going to get sued for infringement by somebody. Have an attorney do it. Spend the money. Seriously, this is worth doing. If you're building a whole brand on this logo, this design, it deserves at least several $100s of your money to get it right, at least. I had a client years ago, about 20 years ago. They started a magazine. There were 3 of them. It was a fitness type of magazine for a very specific market. They had a great name. I begged them to register the trademark. Back then it cost about $1,000 to do the whole thing from soup to nuts. They just didn't. They had the money, but they didn't want to spend it on that. They wanted to spend it on, advertising and going to trade shows and getting advertisers and stuff like that. They said, don't worry, Cliff, we'll do it. So they launched the magazine. The magazine was actually quite a success for about a month until they got a nasty cease and desist letter from a company in California that wasn't even in their industry, but they were using that same name for their in-house employee newsletter. And they had registered the trademark. A simple trademark search would have uncovered that this other company had the name. And this was after they had launched the magazine and they had attracted over $1 million in advertising. They had to change the name of the magazine. Do you know how embarrassing that is? When you have advertisers that have committed to that brand and to that name, seriously, spend the $1,000 or a couple of thousand or whatever it takes. Get the trademark search right. If a lawyer does it and they foul up, if they make a mistake, you can sue them for malpractice. Okay? You have recourse. If you do it yourself and you foul up, well, I don't think you can sue yourself in any jurisdiction that I'm aware of. I haven't really checked that, but suing yourself is not really something that's it's easy to do in most states. Okay, so if the trademark search comes out clean, now you file the application. There are 2 paths you have to follow here. You either have to demonstrate actual use, which is the stronger application, or intent to use within 6 months. That's the key. You can do one of the 2. So let's say you're starting a company, you haven't really launched the product yet, it's all being manufactured in China, but you want to get the name nailed down. The trademark office will let you do that, but you have to follow up within 6 months and show that you're actually using the mark in commerce. You must specify precisely the goods or services, and you have to use the categories in the Trademark Manual of Examining Procedure. And there's the web link to it. Last time I looked, it was over 800 pages long, and there were literally thousands of trademark categories. And you have to pick which ones apply, because you don't just file a trademark for Cliff's Antiques. You have to file for a certain category. So you're filing a trademark for Cliff's Antiques in the category retail sale of antiques. That's the category. That's how this works. If you have a product or service that goes over multiple categories, you can register for multiple categories, but you have to pay a separate fee for each one. Those are considered different applications. So when I tried to file my trademark application for Bienix, my desktop publishing company, I wanted to register it for books, periodicals, web-based content, and publications in general. And there was one other category. TV production was the other one, radio and TV production. To file an application for all 5 of those categories, I would have had to pay, and this was back in the early 1990s, roughly $10,000 in filing fees for all those categories. Every category has its own filing fee. So I had to really sit down and think, okay, which category is the most important of these that I really want? And books was obviously the one. I just registered it for book publishing, which was only, I think, $750 or something like that. The differences are staggering. The more categories you go. And there are literally thousands of categories. So again, another reason to use an attorney to help you figure out the right categories that you need to register for. You can't just register a name for everything. For all possible products or services, you have to spell out very precisely, and as you develop new products or services, you may have to file a supplemental application to the trademark office for that category, which should be pretty easy to do. In most cases, if you have a registered trademark for one category, they probably will allow you, it'll be a much easier examination process to get one for a new category, but I can't assure you that will be the case. There might well be somebody else using that name in that other category. Okay. So now you filed your application, you paid your filing fee, you got the categories down. Now you go through a 2-step examination. The trademark office gets your paperwork, they look at it, and within 1 week they look at it. If the application was not filled out properly, they send it back to you with a little note saying what you have to do differently. If you filled the application out properly, you get a serial number, and they notify you of the serial number. Now, that does not mean you have a registered trademark. It just means that you passed the initial test. That's all. Now you go through a more detailed examination. This is the one where the examiner determines if the trademark can be registered. It's not descriptive, it's not disparaging, it's not being used, it's not confusingly similar to any other trademark. This process normally takes about 2 to 4 weeks. Lately, I think it's running about 6 to 8 weeks or possibly longer. And then what happens, at the end of that process, one of two things happens. If there's no objection, if your application is clean, they publish it in the PTO Official Gazette, which is their official publication. If they do have an objections, you get a letter called an office action, which sets out their objections and tells you what you have to do. And it's usually a pretty friendly letter, but you must do it. So for example, I got an office action when I filed my Bienix application saying, hey Cliff, your application looks good, but you're not really using the name in commerce. Send us 2 copies of one of your books with one of your book covers with the name Bienix on the spine rather than the little b, and you'll be fine. And that's exactly what I did. They'll tell you, they're actually pretty proactive. They'll tell you exactly what you have to do to get over the objection. If you don't respond within 6 months, your application is abandoned. Gone. You have to start all over again. It's not a dismissal with prejudice. You can reapply, but you got to go through the whole process and pay the fees all over again. But you only get this one response. They're not going to engage in a dialogue with you. If you respond within 6 months and you still haven't addressed their concern, at that point they issue a final refusal. And that is what we lawyers call a dismissal with prejudice. You cannot reapply at that point with the trademark office. You have to challenge the trademark office's decision in federal court, is what you have to do at that point if you get a final refusal. Not worth it. Okay, but let's say that your application passes the examination process. Now it gets published in the PTO Official Gazette. Basically, anybody, this is a publication, it's available everywhere, it's online. Anybody who believes that this mark is confusingly similar or who thinks they're going to be damaged by it, they have to respond within 30 days from the date of publication to file an opposition to registration. If they do file an opposition, you are then within the internal trademark office court. That's not the exact name of it, but the trademark office actually has a court within the trademark office to resolve these claims. You do not have to go to federal court. It can be done within the trademark office, but that's what happens. But if nobody objects, then you get finally the registration certificate, which is, at that point, you have a registered trademark. When you get your registered certificate with your serial number on it, that's the victory that you're looking for. That says you got a registered trademark. If the mark was, if you filed an actual use in commerce application, you usually get this within 3 months, assuming, of course, no one objects within the 30-day publication period. If the mark was if your application, though, was intent to use and nobody objected to it, you get something called a notice of allowance. Remember the 6 months. Intent to use means you're going to use it. Within 6 months, you have to give the trademark office specific proof, but they usually will spell out in the registration, but they'll tell you exactly what they're looking for. You've got to provide it within 6 months. You can request a 6-month extension, but only once. That's it. If you can't get them the proof within a year, your application is considered abandoned, and you go right back to square one again. It's a dismissal without prejudice. It's not a final refusal. You can reapply, but then you got to go through the whole process again from square one. Okay. Let's talk about cease and desist letters for arrangement. Remember, I said even with a registered trademark, you can still be sued for infringement if somebody can prove that they were using that mark in commerce before you registered or before you applied for the federal trademark. They can still do it. So someone can still send you a cease and desist letter. They are allowed to use that trademark in that particular area. In a situation like that, what most attorneys will do is they'll negotiate something called a coexistence agreement. That's a very specific form of document. It basically says, look, we're using the same mark, but frankly, we're not doing exactly the same thing, so here's the deal. It's almost like the mafia. You know, picture a bunch of mafia guys sitting around a poker table, you know, smoking cigars. And this is what it sounds like. So Louis, look, here's the deal. You stay out of the Bronx, I'll stay out of Brooklyn, and we'll be fine. That's kind of what a coexistence agreement sounds like. And it's perfectly legal, though. This is not an antitrust thing or anything like that. It's simply saying, look, okay, you're using this mark. You've got this small restaurant in Illinois. Look, I don't really care about that. But as long as you stay within these couple of counties and do not open new branches outside, I'll be perfectly fine with that. I will allow you to use this name. I'm not going to say anything about it. That's what a coexistence agreement basically is. Or a license. I mean, what you may do is you'll simply say, you know what? I mean, and I've actually done a couple of these where the other side says, you know what? Why don't we just simply grant you a license to use the name? That's all. $1 a year, something like that. The only thing is, though, if you guys ever go out of business, you got to change your name. Or if you get sold out to somebody a lot bigger, you have to change your name at that point. But we'll let you use it for now, you know, $1 a year or something like that. No reason to go, no harm, no foul. A good thorough trademark search, though, will avoid that. A good thorough trademark search should be able to tell you if anybody like that is out there. So here's my bottom line. Very technical topic. I could easily do a 3-hour program on each one of these slides, by the way. I easily could do that. Pick a name that's trademarkable, memorable, and I don't know if this is a word, domain nameable. That's not a word, but make sure you can get the domain names. You know, the .com, the .org, the .biz, the .us. Make sure you can get them all. Use your mark in commerce aggressively, whether you register it or not, especially if you're using a common law trademark. Remember that acquired distinctiveness thing. You want to get that brand out to the point where everybody knows when they see that mark, that's you. You know, market your brand aggressively, hire a lawyer to do a very thorough trademark search before you register, and do not attempt to register a trademark without professional help. I wish I could say that this is one of those things you could do yourself, and I have had clients who have done trademark applications and they've been able to get their stuff through, but they tend to be very engineering type people, they're very, how can I say it, they're very good at detail. Trademark applications are all about detailing. You have to have a lot of patience and you got to get everything right. It's like filing an IRS application for like tax exempt status. If you get one thing wrong, they bounce it. And they're not always as articulate about telling you what you did wrong as they should be. So get somebody to help you who can do that. If you're the kind of person who doesn't like filling out government forms in excessive detail and reading tons of regulations and going through the trademark examining, the TMEP, looking for the exact right category that you should be registering in, get somebody else to do it for you. Okay, that's it. These are 2 of my best-selling books. There's a couple of things in there about trademark. The eBay Seller's Tax and Legal Answer book, although there's lots more stuff about copyright. Generally, eBay sellers don't get into too much trouble with trademark. Where they do get into trouble with trademark is there's a thing now called private labeling now, where what they do is they bring generic product over from some other country, usually it's China, and they put their brand on it, and then they sell it as if it were their merchandise, which is legal to a point. But what a lot of them do, they get a little too aggressive. They go to Walmart, they buy a crate full of stuff that is already trademarked merchandise, and then they take off the old trademark and put their trademark on. That's not just trademark infringement, folks. That's theft. That's larceny. So be very careful. If you know anybody who's selling stuff, you know, online as a reseller for other manufacturers, make sure that they're not violating the manufacturer's trademarks or that they have a consent. Whenever I do a reseller agreement for an eBay or an Amazon seller, I always make sure that the brand owner gives them the license to use their trademarks so that they can use them on their Amazon product page or their eBay store or stuff like that. Make sure they get the permission of the brand owner if you know anybody who's doing stuff like that. So with that, I'll be quiet now. That's really all you need to know about trademark, and now let me try to answer your questions as best I can, keeping in mind, of course, that none of this is really advice. Men.
I have alphabets and more on my website. I do alphabets and other things. I have the letter A and with an apple and a worm wearing glasses coming out of it. And it changes depending on where it's usable. So sometimes it's on the right-hand side, the worm's on the right-hand side, sometimes the apple's on the left-hand side. Mm-hmm. Do I need, and also his name is I am a reader. So what do I do with all
right, wow. Okay, so let me just say, it's a graphic. It's the letter A. First of all, you know that Google just formed a new company called Alphabet Inc. Do you know that? It's the new company now that's going to be like the umbrella for all of their non-search engine related businesses. They're trying to reorganize to make themselves a little bit clearer to people how they do stuff and report themselves financially. So the idea, like a letter A, like on the side of a children's toy block or something, with a worm coming. The idea of a bookworm as a character, a worm with a pair of glasses on it, is not really that original.
That's what I'm saying, I don't know where I saw it.
Well,
I
it's a
don't know if
bookworm.
that's what that-
I mean,
Yeah, it's a
if I use the word, if I utter the word bookworm, what image comes
Oh,
in?
yeah.
You know, a worm wearing a pair of glasses like I wear. That's the image. So I think you're going to have an issue. It's not so much trademark as it is copyright. I think I got to believe that somebody else has a copyright to that similar character. You might want to say that, you know, the I'm a reader name, I don't know. You know, if you gave him the name Herman or something like that, I mean, or Aloysius or something, give him a cute name like, what was the guy of the cartoon about 10 years ago, the Aardvark, who wears a sweater, he's kind of a nerdy guy. Arthur, yeah. That might be a better way to go about it. Give a character a name and don't make him look like the generic bookworm. Give him a little bit of street cred. Give him some hip hop cool or something like that. You know, something like that might actually work, something like that. Right now, what I'm hearing as a trademark, I would be worried about it being confusingly similar. I mean, it's not descriptive, it's not, I mean, it doesn't fall into any of the other categories that would make it not trademarkable, but I would be worried about it being too confusingly similar. I think if you really did some research, you discovered some other bookworm characters that look almost exactly like what it is you're doing.
Like I said, I don't know, I've been doing it for so long, I don't know if maybe I did see it somewhere else, I don't think so.
And that's the problem. You know,
Piece here, piece there.
that is a major issue, by the way, and especially in copyright law. There's a famous case involving remember Art Bookwell, the columnist? He also did screenplays for movies, which a lot of people don't know. And back in the 70s, he circulated a concept to the various Hollywood studios. It was a movie about a young African prince who decides he doesn't really want to marry the girl that his father has picked out for him. So he and a best buddy stow away on a freighter and come to the United States. And it's all about their adventures trying to adjust to American culture. Now, what movie have I just described? Coming to America, right? In fact, he even suggested in the proposal, what's his name, as the star, Eddie Murphy, as the star. He showed it to a bunch of movie studios. They all turned him down. They said, kind of cute, whatever. But then several years later, some people at Universal Studios were looking for a new thing for Eddie Murphy. And seriously, the testimony is fascinating because the executives that sat in the room didn't remember Art Bookwell's pitch. They thought that they came up with this as a new and novel idea. It was like a repressed memory kind of thing. That happens a lot in the copyright world. You know, you think it's original, but you saw it years ago. You just don't remember that you saw it years ago. That's why the search process is so important here, and especially if you're going to use it as a trademark. That can be devastating. You know, there's only so many you can do a cartoon worm. Come up with a different way, or put him in some clothes or some stuff where, you know, he doesn't look like anything else that's out there. Yes, we've got you guys over here.
Yeah, so a character name, for example, a unique character name, is that trademarkable?
Okay, a character name. Generally speaking, characters are copyrighted. They're not trademarked in general.
Like, let's take, for example, like, let's say Harry Potter.
Right.
The name Harry Potter, would that be trademarkable?
I believe so. Well, now especially that the books are already out, I think they might be able. So, for example, if someone were to do a Harry Potter line of merchandise,
Right.
for example, I think the name would definitely be trademarkable, but only by J.K. Rowling or whoever owns the copyright to that, I think. There'd be a question of ownership there.
Yeah,
I don't think anybody can just use the name Harry Potter. Seriously, the trick here is, again, remember, we're talking not about names, we're talking about marks. They have to be used as on products or services to identify them in the stream of commerce. So Harry Potter as a character in a book is not a trademark. The Harry Potter brand of cauldrons or something like that, or toy Halloween toys or something like that, that would be an example of a trademark. It has to be used to identify products or services. You're talking copyright here. Characters can be copyrighted independently of the books that they are in. So, for example, Captain Kirk and Spock from the Star Trek series have their own independent copyrights, and the owners will sometimes allow authors to do what they call fan fiction, where they can use these characters in certain ways, and the company won't come after them for copyright infringement. But you're talking copyright world there. You're not talking trademarks. But if you have a popular character, so for example, King Arthur Flower.
Right.
There's actually a King Arthur Flower. Of course, King Arthur has been dead for hundreds of years. I don't think he has any estate. He's quasi-mythical anyway. He's legendary. But that would be the kind of thing where you'd be in the trademark world. You know, King Arthur with his bushy beard and he's in a knight's costume and stuff like that. That would be an example of
like merchandising, like
Yeah.
let's say Harry Potter.
Correct.
A movie or a book.
Exactly. Oh yeah. Oh yeah. So for example, Buster Brown is a good example, and his dog Tig. He was the trademark for years of the Brown Shoe Company. He became a popular cartoon in the early 1900s. People liked the character so much that people started making up stories, and they actually hired cartoonists to make Buster Brown and Tig cartoons with his adventures and all that kind of stuff. That's an example of how the trademark and the copyright world interface. That's the best example I can think of. Madame, hi there.
Since we're talking about names, and
Right.
that's a blurry area, and what comes to mind for me is, so Newman's Own. So if Newman's Own is trademarked for salad dressings and food categories, what would happen if somebody put in an application for Newman's salad dressing? Does he then have rights to the name?
You're making salad dressings out of humans. I can think of a lot bigger legal problems with this business plan than trademark issues. No, Newman's Own is a trademark, as is the caricature. If you ever buy a bottle of Newman's Own, there's a caricature of Paul Newman, and he's wearing different outfits depending on what the salad dressing is. Those are all registered trademarks.
What I'm trying to drive at is the word Newman's. Does he have exclusive rights to use Newman's, even though the trademark is Newman's Own?
Okay. The short answer, the question is, does he have a trademark on the name Newman if if he has the trademark on Newman's Own? The answer is no. Anybody with the name Newman can do something else. What they shouldn't do is they shouldn't use Paul Newman's name or likeness, because that's a violation of his right of publicity, or he's dead now, but his estate's right of publicity or copyright. And also I would avoid doing, let's say for example, you did a Newman brand of salad dressing. I would definitely make sure that the label doesn't look anything at all like the label that he uses on Newman's Own. But it might be, I don't think you can trademark the name Newman. He might, the answer is I'll be honest with you, I don't know. He might have trademarked the name Newman or Paul Newman for salad dressings. He might have. So you might not be able to do a salad dressing as Newman something else. But another type of food product like Newman pasta or something like that, you might be able to get away with that. Someone's going to have to look at that. That's actually very interesting. I don't know what they did there.
Another one that comes to mind is Tiffany's. So that's a name.
Oh, yeah.
But they obviously trademarked it. And
Yeah.
I noticed also there's a Tiffany's small jeweler that had that name out in the Midwest long before Tiffany's, the big company. So they're actually,
Well, exactly. Let me tell you something, though. If you're doing anything involving jewelry using the name Tiffany, you're going to get nasty letters from their lawyers. They are ruthless. eBay sellers have problems with Tiffany all the time. When they see, even if it's genuine Tiffany stuff, even if they have the box, even if they have the documentation, the first thing Tiffany does is they write a letter, they shoot off an email to eBay saying this guy is selling counterfeit Tiffany merchandise. And there's a good reason for that, by the way, before you hate them for that. There was a time, by the way, in the early 90s when eBay was still the wild west of web commerce, where certain unscrupulous people were putting up genuine Tiffany boxes for sale on eBay, but without jewelry in them, just the boxes. Now, let me ask you, who would buy an empty Tiffany box without jewelry in it? Answer, a cheap guy who wants to impress his lady friend. Let's face it, not only is that fraud, not only is that trademark infringement, but I'll just say 3 words to you. If anybody's here thinking about doing something like that, accessory to murder. That is, because if she finds out about it, that guy is dead, D-E-D. So.
in the case of Tiffany's name, so if they have Tiffany's as a registered
You saying Tiffany's not a registered trademark? I don't think that's true. I think it is a registered trademark. Oh, yeah.
No, that's what I'm saying. If it's a registered trademark.
Right.
So here's my question. If it's a registered trademark, do they then have ownership on the word Tiffany's for anything jewelry related?
The short answer is if they have a trademark on the name Tiffany's, remember it has to be for a category. You have to look at those categories. So jewelry would definitely be a category. If anybody else is using Tiffany's in the jewelry world, they're going to hear from the big Tiffany's company, the Robin's Egg Blue company. If they're doing something else like pasta or something like that, Tiffany pasta, the answer is I don't know. But remember my little example about the Microsoft toilet tissue? Okay, if the name is being used in a way that could be seen as disparaging Tiffany's, they might object to it for that reason. Not because you're confusingly similar, but because you're disparaging them, you're making fun of them, you're implying a false connection. By the way, not only is Tiffany's trademarked, but the Robin's Egg Blue color that they use on their boxes is also a trademark. You cannot use that specific shade of aquamarine if you're selling similar jewelry products, because it looks too much like a Tiffany's box. Yeah. Colors can be trademarked sometimes.
So if you were going to register a name, you would want to do, instead of Newman's Own, you would want to do Newman's for your category, because that sounds like from what you just said.
The answer is, can you use the word Newman's? The answer is it would depend on the category. And if you're getting too close to what the Newman's Own people are doing, they're gonna send you a nasty letter.
I'm saying, assuming that it's the same category. So based on what you're saying, it sounds like you would want to register Newman's rather than Newman's Own, because that would give you greater protection.
The shorter answer is, I see where you're going with this. If you have a choice between registering a narrow trademark and a much broader trademark, I would advise that you register the much broader trademark if it is trademarkable. If it's trademarkable. So if you have a choice, just to use this, if you have a choice between trademarking a Newman's Own or a Newman's. See, the reason I think, and this is just, I don't know the history here, so if there's anybody from Newman's Own listening to this tape, please forgive me. The reason why I think they called them Newman's Own is because they probably couldn't get the trademark for Newman's. There were too many Newman's brand other things out there, and the trademark office didn't like that. That's why they called it Newman's Own. That's my suspicion. It's a guess, but it's an educated guess that's why they did Newman's Own. Also, too, it kind of implies the tie into Paul Newman, who was, let's face it, that was his character was what sold that brand. You know, he was well known. He was a gourmet. He made a lot of his own salad dressings. This was well known in Hollywood and stuff like that. You know, he used to give them as gifts to his Hollywood buddies every year. So he decided to do something charitable in the last years of his life. And this was, the whole thing was meant to tie into him personally, not to some artificial, hey, Alfred E. Newman. Mad Magazine, there's another Newman. There's a million Newmans out there. Sir in the back in the green sweater.
Yeah.
Hi there.
Thank you. You mentioned that if you have a prior use, somebody has a prior use of the name.
Right.
Even though that name is not registered, but which violates a registered trade name.
Right.
Will that establish a denial of the...
Okay, the question is, if you, let's say there's a company out there that's using a trademark. They didn't register it, but they're using a registered trademark, and by some miracle, you are able to get both a registered trademark and the .com, all the web URL extensions without the other company objecting to any of that. The short answer is you then would have the registered trademark. They could not take it away from you, but they would still be allowed to use the name for the business that they're in, because they did have it before you did. They were, and if they could prove it, if they could prove that they were using the name in commerce, but I mean, and shame on them for not registering the trademark, but maybe they were just too cheap, you know, to hire an attorney and do it. Again, another reason why you should hire an attorney. If you have a name that is trademarkable and you don't, you're opening yourself up to exactly what you're saying. Somebody else is going to get the registered trademark, and they're probably going to be somebody bigger than you, and even though you do have the legal right to continue using the name, they're going to beat the crap out of you in court because they got millions of dollars to spend on legal fees. That's the reality here. You know, I mean, if I'm using a name and Microsoft gets a hold of it, I'm changing the name. I'm not fighting that battle with, with Redmond. I'm not doing it. Okay, anybody else? Sir, over here.
Yes, we own two registered trademarks. One of the trademarks, since we received the trademark award for the mark itself, which is a name, we hired an artist to design a logo to go with the mark. Now, do we need to register the logo with the mark also, or is that...
Okay, you got a registered trademark for a name, a word, I'm assuming, and now you've done a logo, which is also, are you going to be using the logo on your packaging, on your products and services? You are going to be using it. Okay, then the answer is that should be separately trademarkable. And you should have an easy time of it because if you own the trademark for the word, make sure that when you file the application, you include a copy of your previous trademark filing so that the examiner knows you own that other trademark. This is just a brand extension is really what it is. And I don't think you're going to have any problems with that. But again, a separate search, that logo could violate someone else's logo. Remember the movie Ghostbusters? Remember the Stay Puft Marshmallow Man? Doesn't he look like somebody you know? Looks a little bit like the Pillsbury Doughboy, doesn't he? There was some legal nonsense back in the 80s. It was all settled. It didn't actually go to court. But there was some, the Pillsbury people were a little concerned about the Stay Puft Marshmallow Man, looking a little bit. Now, of course, there are a lot of people out there that kind of look like the Stay Puft Marshmallow Man, and We will not be very specific about that, at least not in this class. Ma'am, talk to me.
We have a trademark that we're, for a particular product. It's the name of a product. We have a LLC business, but we've trademarked the name for a particular product.
Yeah. By the way, a very good point, not to interrupt you. It's always a good idea not to have your company name be the same as the trademark that is on your products or services. I mean, initially that's okay, but sooner or later you're going to want to branch out of just that one product or that one product line. And by having the trademark separate from the company name, it gives you a lot of flexibility. Procter & Gamble has over 10,000 different trademarks that they use, and it just makes their life a lot easier that they're not identified with any one of those specific products. But please go ahead. I just wanted to make that point.
So we have it on the product and I have a domain with it. We're now in the NOA phase of the trademarking. We passed the opposition. It's being manufactured currently in China right now. My question is, should I, because I have 6 months, I just got this.
Was this an intent to use application? All right. Well, then you have to be, okay, so you got your notice, you got your NOA, which is your notice of acceptance. Okay. You have 6 months to show them proof that you are using the mark in commerce. Intent of use, you can request a 6-month extension, but they'll only give you one. They want, you got basically 12 months from the date of your NOA to the date. Read the NOA because it'll tell you exactly when the deadline is. You have to show them that you are using. So I would put together something, even like some dummy packaging or something like that, and put it on something. The mock-up is good, but they want to see actual use. So have them do like 5 of them or something like that, and send those to the trademark office. That's what they want.
I should get the product in 45 days.
Yeah, okay. Well, just again, look at the date. As long as you have the actual product, then all you have to do is send them a couple of the boxes, the packaging, and they're fine with that. Whatever they ask for, you should be okay, but do it within that 6-month or the 1-year period. And if that 6-month period is getting close, be sure you get the extension. Because if you miss that deadline, then it's considered, your application is considered abandoned, and you got to go all the way back to the beginning and do it all over again. Although this time, you'll probably be able to do it as an actual use because you now have the packaging. That should be a little bit of an easier application. Intent to use applications are always scrutinized a lot harder than actual use. I mean, if you have a choice between filing an intent to use application and filing an actual use application 3 months from now when you actually have the product in your hands, wait the 3 months and file the actual use application, because those always, I mean, there's no guarantee that they'll sail through, but they tend to have a much easier time going through the trademark office than the intent to use. Anybody else over here? Okay, Madam.
How do you define, so use in commerce, that's confusing to me. How do you define first in use versus first use in commerce? What's the difference between the two? And does use in commerce mean actual sales, or can it mean
No, okay.
voting?
Yeah, the term use in commerce is defined in the trademark statute. It means basically anything that is actual use in commerce. So for example, when you get your boxes from China, even though you haven't sold anything yet, you can still send the boxes to the trademark office with a note saying these are in our inventory. That is use in commerce. You do not have to have actual sales, no. You do not have to have actual sales. But you do have to be actually doing it. So for example, they will look at your website and they're going to want to see the stuff being advertised there. They're going to want to see that with the R in a circle. They're going to want to see you using the name. And whatever you do, don't change the name between the time you get your registered. This is a big mistake that people make. They get a registered trademark, and then when they do the packaging, the consultant or the designer says, you know what, it'd be a little bit better if we made that O more of a Gothic O than an Arabic O. And, oh, okay, that's great. Guess what? That's a whole new different mark now. That's not what you got the trademark for. So when you go and send that package in as proof of your actual use, they're going to bounce you, because you changed it. You didn't use exactly what the trademark office approved. That's where I got into trouble with my application. It wasn't that Bienix wasn't trademarkable. It was that I wasn't using the exact mark on my book covers, my stationery, my packaging. That was the problem. I was using something else.
In that case, because what if you're just trademarking the text, the actual word versus, because are you describing?
It doesn't matter. No, they're saying that just you don't change anything. Once you get the registered mark, you are locked into that. If you change it, you got to go all the way into a new application process.
So the mark, so if you're trademarking a word versus a logo, then are you saying that it matters what type of font you use for the word?
I don't think it matters what font you use necessarily, but if it was a graphic to begin with, so for example, the eBay, logo, the letters are different colors. They're the 4 primary colors. If you were to use eBay without the 4 colors, that would be considered a different mark, believe it or not. The eBay mark is not just the word, although I'm pretty sure they've trademarked the word eBay itself. But the initial trademark was the eBay with the 4 primary, each letter was a different primary color. So just be careful about stuff like that. If you change the look of the trademark, that could be opening the door to a new application, is what it could be.
So what does first use mean versus first use in commerce?
Well, no, it's just use in commerce, not first, actual use, or intent to use, not first use. The first use in commerce comes into play in infringement actions. So who first used the mark in commerce? So if someone sues you for infringement, the battle is going to be over who first used this mark in commerce. Were you using it before them, or were they using it? And that's where the first use in commerce, comes about. And that is just that's a question of documentation. It can get hairy. Yes.
Just to answer, well, 2 things. On the packaging, I don't have, because at the time we were doing all this, we didn't know whether we were going to get the trademark registered.
Right.
And it hasn't all been completed yet anyway. We're in the NOA stage. So we don't have the little symbol after the word. Those 2 words. Right?
Well, no, that's fine. That's okay. You can always add it later on. Yeah, but the thing I'm worried about, you can amend, by the way, you can amend a trademark application. So if you do decide halfway through the process, you know what, that O should be a Gothic O, a red O rather than a purple O, you can amend the trademark application while it's in the examination process, so you can do that.
And then, in sort of answer to your question, when we did it, because it's 2 words that describe that, are for this product. And when it came back, it said, we can use that and we have the rights, to those 2 words, but we don't have anything specific for color or font, that wasn't part of the trademark.
Okay. All right, so that's good. Again, you try to make your application as broad as possible so you can use as many variations as you possibly can without having to go back to get a new mark.
There's no set colors.
Yeah. So that's answering your question. If you have the choice between Newman's and Newman's Own, that's that same question. Go for the broadest possible mark you think you can get away with. Yes?
Can you trademark a artist's signature or a mark that they put on their jewelry or else on?
Can you trademark an artist's signature? The answer is no, not without his consent or her consent. You cannot do that. No, that goes into, that's not, I mean, let's put it this way. Most artists do not have their signatures as a registered trademark, although they can do that. Most don't. But that's more of an issue of their right to publicity in that kind of thing. That's a copyright concept. We all have the right to our right of publicity, and no one can steal that from us without our consent. So if you're going to use my signature, why would you ever use my signature? It's awful. But it doesn't look like anything. But seriously, I think you would have to get my approval for that. Whenever you're using something that belongs to somebody else, you got to cut a deal with them. So for example, Colonel Sanders was a historic person, He was a real guy. Harlan Sanders died about 30 years ago. Now they got the young guy playing him, on all the TV commercials, But the estate of Colonel Sanders still owns the right to his name, his likeness. They're paying the estate a fortune, to allow this, young guy to revive that character again, because he was a real guy. He was a real person. So anyway, okay, anybody else? Okay, listen, you guys have been a great audience. I'll hang around for a few minutes. Thank you very much.